righty. Perfect. So again, thank you everyone for joining us today. We greatly appreciate it. My name is Kelly. I'm the resource specialist here at the Jefferson Franklin Community Action Corporation in the Small Business Resource Center, or SBRC for short. We have a lot of abbreviations at our agency. So with that, what we do is we assist clients at no cost to them. We have two business coaches, Michael and Brittany, and then we also have our director, Marquita, and they were able to get on this call today. So what I'll actually do here is go ahead and turn it over to Marquita real quick, and then she'll introduce you to the business coaches, and then the business coaches will introduce you to Dan.
Everyone. Like Kelly said, I am the program director for the Small Business Resource Center. We are funded through a grant from the SBA. That's what actually allows us to provide these services to the clients free of charge, such as the training you're receiving today. This is all paid for through the grant from the SBA. We have an office location in Hillsborough, which is where Michael is, and one in St. Clair, where Brittany is. And then Kelly is our resource specialist. He's also out of the Hillsborough location. And so I'm going to go ahead and pass it over to Michael. Thank you all so much for joining, and I hope you have a wonderful day and that you enjoy the training.
Hello, my name is Michael. I've been small business coach here in Hillsborough in Jefferson County. Brittany is in St. Clair, and we do all the contacts and getting clients in touch with spokes such as Dan. That's pretty much the gist of that. I'll let you guys talk to Brittany.
I'm just going to pop on for a second and say hi because I have a lot of background noise. But hello, thank you all for joining. I'm the one who sends you guys lots of emails, checking in with you guys and making sure that you guys are prepared for the trainings. I am absolutely happy to be here, and thank you for joining.
All right, Dan, so I'm going to go ahead and while you are introducing yourself, I'll go ahead and get our presentation pulled up.
Okay, well, good morning, everyone. My name is Dan McNamee. I'm an attorney. I'm a partner in the law firm King and McNamee. I've been practicing for about 20 years with my same law partner, Kevin King. Our firm does primarily, we're a general practice firm. We do a lot of corporate work, commercial transactions, a little bit of everything, including, advising clients on employment matters, which kind of brings us to today's presentation. Really, the changes in the marijuana law have made, for kind of a muck of what employers can and cannot do, what people that are consuming marijuana can and cannot do when they're doing it, and that sort of thing. So hopefully you'll find today to be informative, and you can take away at least some maybe best practices, if you will, on how you want to handle these issues in your workplace. So the topics really we'll go through today are the medical use of marijuana, some background on the law when that passed in, I think, 2018, the recreational use of marijuana, which just passed this past fall, and then how this impacts employers and, some protections that have been enacted and some, I guess, dispositions of some prior criminal histories and things like that, all of which, affect how employers operate, what they do, and how they deal with this issue in the workplace. Kelly, if you can go to the next slide, great.
Absolutely. And I would like to say, again, we do have a lot of information to go over. And again, I know everyone is going to have questions. So what you can do if you have questions, either hold on to them. We are going to have that live Q&A session with Dan at the end of the presentation, so you can ask him questions directly, or you're more than welcome to put your question in the chat. And then once we get to that Q&A session, I'll take Dan through those questions. So however you would like to do that. And then we can always go back to to any particular slide you would like to see. But just please go ahead and hold all questions until we get to that Q&A session. We would really appreciate it. Thanks so much.
Okay, so the first topic really is the medical use of marijuana. And, you know, it was improved in 2018. And this is just kind of a background, you know, basically state licensed physicians could recommend marijuana for medical purposes to patients with qualifying medical conditions. And those qualifying patients and their primary caregivers then could obtain a medical marijuana ID card when certified by the physician, and that allowed them to then grow up to 6 marijuana plants, purchase up to 4 ounces of cannabis per month from an authorized dispensary, use medical marijuana for treatment under a physician's supervision. The protections also included possession of marijuana for less than stated limits where an out-of-state patient had an equivalent identification or authorization card. So if somebody, you know, from another state came in and they had a medical marijuana card, they would be treated as if they had one issued by Missouri. One thing that the 2018 law did not provide was any protection for qualifying patients, medical marijuana ID card holders, in the employment context. So the next slide here just shows, you know, how the Constitutional Amendment 3 passed. It was, I don't know if that's close or not, I guess pretty close, but obviously it did pass and it became effective. February 8th really was the date where everything started to be sold and dispensaries were open and some other factors and things began. So the recreational marijuana was approved by Amendment 3, and it permits the recreational use by persons that are 21 years or older. They can legally purchase and possess up to 3 ounces of marijuana. Registered individuals, which is a separate registration, they can grow up to 6 flowering plants, grow 6 non-flowering plants, and 6 clones contained in a locked space within a private residence and out of public view. In addition, Amendment 3 provides for the expungement of certain criminal history records. And there's a couple levels. The first was, you know, all misdemeanor marijuana offenses for anyone who was no longer incarcerated are to be expunged by the courts within 6 months of the effective date, which the effective date was February 8th, so June 2023. This comes into play, and we'll talk about it a little later in the employment context, to the extent that any employers are doing criminal background checks. I don't know if misdemeanors are inquired about generally, but if they are, and there is a misdemeanor, and if it's a you know, marijuana offense, even though it may still appear on the record, if it is a misdemeanor offense, essentially it's going to be expunged, and the courts are it's going to take some time for the court to deal with that. And so I think the best practice here is in what the consensus is that it really needs to be treated as if it's not in the record. In addition, certain felony convictions for marijuana possession of up to 3 pounds are also going to be expunged, and that is to occur within 12 months of the effective date. So, you know, close to December, I think is what they're saying. I guess if it was effective January 1st, but ultimately, the same impact as the misdemeanor offenses. If it's simply possession and not sale to a minor, or then ultimately those kinds of convictions will be expunged. So in investigating any background check, you'll want to consider those things. The other thing that Amendment 3 did, which is really kind of what we want to discuss today, the majority of the information, relates to the employment protections for qualifying medical marijuana patients, those persons that have a medical marijuana ID card. And so the first thing I wanted to touch on is, all of this information that we're presenting today and what you can and cannot do and how you need to treat, folks that are consuming recreational marijuana or medical marijuana. All of this goes back to what your specific policy is in the workplace. And everyone, if you have a policy, and it kind of assumes it for sake of this discussion, your policy needs to be in place, because without it, there's nothing really, nothing you can do to enforce, if you will. And if you have policies in place that have, drug and alcohol policies, you may want to review those and maybe adjust them. They might say alcohol and illegal drugs. Well, marijuana is no longer an illegal drug for purposes of Missouri law. So those things may want to be updated, and you may want to take a look at those items. But, ultimately, employers need to have a policy in place that addresses restricting the use of drugs in the workplace, or a zero tolerance policy for the use of drugs inside or outside of the workplace as the employer deems appropriate. Now, zero tolerance policy, there'll be an exception for someone that has a medical marijuana card. But if folks have that kind of policy, you need to have it in place to be able to ultimately make decisions that lead you to have a legitimate, non-discriminatory basis for making employment decisions. So, without a policy, if you take an action against somebody for using marijuana, they may have, a claim against you. You have to have backup for your decision. So that's why the policies are important. So what Amendment 3 does not require is to permit medical marijuana use, and certainly not recreational, but employers do not have to permit the use, possession, or being under the influence, which is an issue, while the employee is in the workplace premises or during the employee's hours of employment. So this covers probably remote work, traveling, people that you might have on call, like for a night maintenance worker that has to go to work at an apartment if there's an emergency, et cetera. Just going back, though, to being under the influence, and I kind of said, there may be an issue here. As you probably know, if somebody is under the influence of marijuana, a test is not going to be able to show exactly when that was. And so if somebody's at work and something happens and there's a test given, the test won't tell you, hey, it was at 8 o'clock that day that he ingested or whatever. The marijuana, it shows up for 30, 45 days, I guess, depending on the test, maybe longer. So one of the things that we'll talk about a little bit later is having some objective factors or tests, and maybe having someone, if an HR department or a manager, maybe perhaps do some training. We think that there may be a development in that, just to give some objective factors that somebody can look at and say, okay, X, Y, Z, this looks like they were under the influence at the time of the accident, or when they were at work and they did something stupid, whatever it might be. So we'll talk about that a little bit more in depth, but that's something to consider. Drinking on the job, sometimes you can smell alcohol on the breath, things like that. And marijuana may be the same, but alcohol will show up in a test, a breathalyzer test, something like that. Whereas the test for marijuana, it could have been a month ago that the person ingested it, and it's still showing up in the testing. So again, as to recreational use, Amendment 3 does not impact employers in any fashion. I mean, there are no protections for a person who engages in recreational marijuana use, and there's no impact on the employer's right to have a zero tolerance policy for recreational use. So if you have a drug-free workplace that you don't hire people that test positive for marijuana, you're free to do that, and you don't have to hire somebody that uses marijuana. Or if it's simply no drugs in the workplace, obviously you prohibit use during working hours, things like that, but you don't care what people do after the fact. That's certainly fine too. But again, there's just because somebody has the right to ingest marijuana doesn't impact the employer's right to say, no, well, we don't want you to work here, or no, you can't obviously do it at work just because it's legal under state law. So the anti-discrimination provisions of Amendment 3, as they impact medical marijuana patients. So essentially what it applies to, and the statute is kind of verbatim here. I didn't put the whole thing into the slide because it's probably a mile long, but it applies to individuals. And when we say the word individuals, that would be current employees and applicants for employment that have a valid medical marijuana identification card that's issued by Missouri, and most likely any other state that has a similar card, would apply for conditional offers of employment, for criminal history, and just somebody that has a card, and it protects them then from discrimination in hiring decisions, termination decisions, conditions of employment. And again, it either because they have a medical marijuana card, because they use medical marijuana outside of work during non-working hours, or they test positive for marijuana. So just kind of going back, I ran through that kind of quickly, but conditional offers of employment that you want to think about in the context of hiring. If you have a policy that is a no zero tolerance policy for your workplace, and any positive drug test is going to prevent somebody from getting a job with you. In the event that you make a conditional offer and the drug test is positive for marijuana, and you have that zero tolerance policy, then you have to take kind of an additional step to determine whether or not that person is the holder of a medical marijuana identification card issued by Missouri or any other state. And that is because they have this protection. And so the thing would be that inquiry would really need to be treated kind of like a health inquiry or a medical condition inquiry that you would do in the event those issues come up. And you want to treat those probably separately and store them separately. Any information about the person's copy of the card or the information gleaned from a discussion. And then if somebody does have a positive marijuana test, but does also have a medical marijuana identification card, then the condition, they're exempt, they're accepted, and you cannot not hire them for that reason. There are other reasons. There are some exceptions to these protections, and we'll talk about in a little bit. The second thing is the criminal history, as we talked about earlier. The expungement of some of these records, essentially an expungement it never happened. So the applicant wouldn't be required to acknowledge these misdemeanor and marijuana convictions, and then those felony convictions of under 3 pounds, provided it didn't involve sale to a minor. So those things are, again, kind of an additional step you'd want to take and confirm. And if you do a criminal history check and these kind of misdemeanors show up, or a felony and it was simply a possession felony and it wasn't intent to distribute or sale to a minor, then those don't have to be reported by the applicant, and you should treat them as non-existent. And again, the court is going to take some time to be able to go through all these files and clean them out. And so again, the best practice is probably to just treat that, if it does show up and it hasn't yet been expunged, if it fits in those categories, to treat it as if it's not happened. The other protection, obviously, in hiring, and then you have in termination decisions. Those will come about. We'll discuss it a little bit later, but I mean, certainly if somebody's a medical marijuana user, you can't terminate them unless you would have a zero tolerance policy workplace, and they would fit in some of the exceptions, which we'll talk about later. And then again, conditions of employment, we just touched on that, clear drug screen, things of that nature. So here are the first, there's a few exceptions that relate to the type of work that the employee is doing, but there's also an exception for government related contracts. And so marijuana is still illegal under federal law, at least for the time being. It may change, it's hard to say, but anti-discrimination provisions do not apply to the employer if the lawful use of marijuana by the holder of a medical marijuana ID card would cause the employer to lose a monetary licensing related benefit under federal law. So federal law still prohibits the use of marijuana and supersedes state law in federal matters. So if any employer might have a government contract that exceeds a value of $100,000, they're generally subject to the Drug-Free Workplace Act. And employers may terminate employees that actually work on those government contracts for a violation of the act, as a failure to do so could result in the employer's loss of a contract. So if a company has government contracts and there is somebody that would test positive for marijuana at any point, and notwithstanding the fact that they are a medical marijuana ID card holder, they can still be terminated if that person is specifically working in furtherance of that contract. If they're doing something else in the workplace that doesn't relate to that, then they're still afforded the protections. It's very specific. They have to be doing work for which the contract was granted. So in the kind of work that the employee is going to be doing, there are the exceptions to the anti-discrimination provisions for the medical marijuana card holders. And the anti-discrimination provisions do not apply to the employee if the lawful use of marijuana by the holder of a medical marijuana ID card would affect the individual's ability to perform job-related responsibilities. And generally, I mean, in this context, you're thinking, is somebody operating heavy equipment? Is somebody, driving a truck, which is kind of touched on in the third bullet point here, versus, let's say, an office setting that somebody's, data entry or answers the phones, things like that. I mean, there are probably certain effects that, the long-term use of marijuana may have on somebody, quickness, or maybe they're foggy in the day, things that, whatever those impacts might be. I think the employers are safe to assume that, if somebody is a medical card holder, you may not want them operating a crane or doing other things that may be unsafe, or if it's within their responsibilities. The second point, in the same vein, things that might affect the safety of others. Somebody that operates maybe a line or something, or it has to start and stop it quickly, or things of that nature. And again, back to equipment. heavy operation, driving, transportation, things of that nature. And so if your, job that your candidate is looking at involves those kind of things, and they are a medical marijuana holder, ID card holder, then you still can decline employment if it would be a safety issue or an ability to perform job responsibilities. The third point here is if it conflicts with a bona fide occupational qualification that's reasonably related to the person's employment. And just to unpack that, you may already know about bona fide occupational qualifications, but just by way of example, if somebody was going to be maybe working in a warehouse and part of their job was going to be lifting boxes, and let's say the 50-pound boxes, if somebody was unable to, lift a 50-pound box based on, a disability, whatever, that would be a bona fide occupational qualification they don't meet. In the context of the medical marijuana, one of the things that comes up are the, Department of Transportation regulations for like commercial drivers. Those laws don't acknowledge the Missouri or any other state's decriminalization or the permit the use of recreational marijuana. So if you're needing DOT testing done on any employee, if they don't pass the test, they're not gonna, they can be terminated. You don't have to hire them, whatever it is. Again, the federal law superseding the state law when it comes to those sort of regulations. So if somebody is a medical marijuana card holder and using marijuana in after hours, they're not going to pass a DOT drug test. So, they're not going to be probably the right person for that job, and you don't have to hire them. The takeaway, I think, from this is really there needs to be a temporal connection between the work being performed and the possible effects of the employer's legal medical marijuana use outside of working hours. And really that nexus is necessary. And again, if we go back to the example of, somebody's going to be an office worker and, maybe answering the phone or whatever, likely probably not an impact to answer the phone, not affecting the safety of others, probably not a bona fide occupational qualification. So if they were a medical marijuana ID card holder, that their positive drug test probably shouldn't impact their ability to be hired, or it should not result in a termination, which kind of goes to another thing. There may be folks at some point that get a medical marijuana card after they're employed, current employees, and there can be some considerations there. If somebody's a, heavy machinery operator and, now they've maybe have an underlying condition, they get a medical marijuana card, they probably will inform you of it because they know you may have testing or it may come up, in which case, you might be in the position to say, hey, this isn't the right person to be performing this job if you're going to be smoking marijuana every night or ingesting it or however they consume it. So anyway, so next kind of thing, just on drug testing. And again, going back to what your policy is and how you want to treat, whether it's a drug-free workplace, a zero tolerance policy. And so we'll just talk a little bit about what Amendment 3 doesn't do in this case. It doesn't prohibit drug testing. And so as we discussed a little bit earlier, for pre-employment screening, if you have a no drug policy, it's okay to do a pre-employment screening. You can do it as you wish. But if the results are positive, then further inquiry would be required as to whether the applicant has a valid medical marijuana card. And as I said earlier, if they did, that person could still be denied employment if the position meets one of the exceptions previously discussed, that they would be working on a federal government contract subject to the act, or if they would be doing a job where that might affect their job responsibilities, the safety of others, or the bona fide qualification, the DOT testing, things like that, that might come up. And as far as recreational marijuana, if you have the policy that you don't hire people that consume marijuana, you can always deny a recreational marijuana user for a positive test. And again, that assumes that it was a zero tolerance policy in place. Reasonable suspicion testing. We talked a little bit about this and those objective factors, but it's, as discussed, really can be a gray area as marijuana stays in the system for some time after consumption. And testing cannot provide evidence of exactly when it was consumed and the time of any impairment. And so, the thought is to consider training for human resources or managers to identify those objective and consistent factors that would indicate the employee is under the influence of marijuana. And again, I think there'll probably be some development in that area for training and to help employers protect the workplace. For post-accident testing, generally speaking, employers should check with their workers' compensation carrier to determine when testing is appropriate. In the case of an accident, and then implement those threshold factors into the drug testing policy. And then you want to go, if there is an accident, you want to try to have a manager, human resources, try to use any objective factors that are developed that would indicate the person may have been under the influence of marijuana at the time of the accident. And then if it's warranted and the test is warranted and it comes back positive, then, you've got at least the first step. Obviously, if it's someone that doesn't hold doesn't hold a medical marijuana card, then you're free to terminate them for if you have the zero tolerance policy. If they do have a medical marijuana card, then what's going to come into play are those objective factors that might indicate, hey, they were actually working or attempting to work under the influence at the time of the accident. So that those factors are going to be important. I don't have a list of them presently, but I think there are probably some obvious, maybe some obvious things. If it's being smoked, it smells, or their eyes are bloodshot, or whatever. Some other things, other ways to ingest it may not be as obvious. But I think that will develop and can be developed. And then the third testing, if someone refuses a test, you can treat that as a positive test. I mean, if somebody had a medical marijuana identification card, there would be no reason for them to refuse a test because they presumably were using that off hours and can explain and would be potentially exempt, save any obvious factors that came up. And then, of course, with recreational users, they would have no excuse. The assumption that anybody that refuses to take a drug test is positive is still, I think, a fine way to look at things, and free to withdraw any offer of employment or discharge or terminate the employee in that instance. One other thing I wanted to talk about just briefly that is not necessarily in the slides is, if there is, say, for example, someone is terminated and they claim that it's a discrimination and that it was because they're a medical marijuana ID card holder. And this wouldn't apply at all to recreational use, but if they are a medical marijuana ID card holder and were terminated, pursuant to one of the exceptions above, the one of those 3 or 4, or for whatever other reason, one thing to note is that these medical marijuana ID card holders are not treated as a class similar to what gender, sex, things like that you would see in the typical discrimination, race discrimination claims that are made with the EEOC and or the Missouri Commission on Human Rights. And typically, any of those claims have an administrative procedure where, if you have a claim, you file it with the Missouri Commission on Human Rights, and then the commission looks at it, and then you have to go through that process first before you can have the right to sue. And you can either go through it with the commission, or you can immediately ask for a right to sue letter. But before you've done that, you can't bring a claim of discrimination in a Missouri court. And so in this case, Amendment 3 and the protections provided, they do not have the equivalent structure, if you will, that somebody would have to go to the Missouri Commission on Human Rights. So it's a kind of a gray area there. And it typically, if it's not included in something under that the Missouri Commission on Human Rights would cover, then there's no redress, if you will, for that person. And I think the thought is that what crafty lawyers are going to do is say, really, there's an underlying disability that this employee has. It's PTSD or something, whatever brought them to have a need to see the doctor and obtain the medical marijuana card. What they're going to try to do is attach that and bring a claim for discrimination, ADA or something akin to that. And so that's the thought as to how those things are going to go forward. But initially, their protections don't necessarily have a remedy. If there was discrimination that occurred, or it's unclear how the remedy will play out. So just kind of a point to bring up there. Let's see. Gosh, I've gone to the end already. I guess, well, we've got 20 minutes. I think that should be good. Kelly, do you have questions or that have, sorry, I'm controlling the slides. Do you have questions that have been put in the chat, or do you want to open it up to questions? What's the best way to go? I know you talked about it earlier.
Yeah, so it doesn't look like anybody put questions in the chat. So if anyone has any questions, please feel free to go ahead and put them in the chat at this time, or go ahead and unmute yourself. Just fair warning, everybody is muted, so you do have to unmute yourself, and you can ask Dan any questions you have, any scenarios, questions, what ifs, things like that. I know there's got to be some questions out there. We attended a chamber meeting not long ago, and that's kind of what prompted us to have this training, because there were a lot of people speaking up with questions there. So please don't be shy, and no question is a dumb question either. Don't feel embarrassed to ask a question, because this is a lot. This is a lot to take in. Oh, and it looks like we've got one in the chat. So let's see. Jana, I hope I'm saying that correctly. So Jana, do you or anyone on the call have an example of a zero tolerance policy?
An example, like a written example? I'm sorry. I mean, I think, yes. We get the chat. Yeah, so I don't have a written example. I don't think that I could share. I mean, I could certainly pull one up, I guess. Let me take a look. I'm gonna lose the. Trying to find
So what I can do, Dan, if you get one
Yeah.
pulled up and if you'd like to
Yeah.
share your screen, I can stop sharing.
Yeah,
And then
I'm gonna
you
see if
you can start sharing your screen if you get one pulled up.
yeah, let me see if I can find one just on like Westlaw here that would be a form.
Mhm. And a lot of times those are, kind of similar to what the sign here is, just stating clearly, you understand that this is a zero tolerance workplace, no drugs or alcohol to be used, while on the job, and there is drug testing. And typically that's something that's in the form of an acknowledgement form, if I'm not mistaken, that an employee will sign stating that they acknowledged that when they accepted the position or when the company enacted that policy.
Exactly. Let me see. I want to see one of my clients might have their see what theirs is. Look, I might have one here. This is just a drug-free workplace policy. I'm sorry. I'm sorry, Kelly. I'm having
So I've
heck of a
got
time.
an example pulled up here.
Oh, good.
Again, this is not, to be taken, don't build your policy off of this. This is definitely something you want to do with your HR administrator or have your attorney do. but this is, just a brief example. And it's kind of hard to see, I apologize, but, alcohol and drugs policy, being under the influence of alcohol or drugs can seriously impair an individual's judgment. The aim of this policy is to ensure the safety of all employees. And, you just go through, all employees and workers will be treated consistently and fairly in line. And just letting them know that the rules of the policy, they are not to, be under the influence and things like that. And then, like I said, typically, you want some type of acknowledgement on that policy so that you have that for your records in the event that something pops up.
I saw another question up there.
So, yep, so we do have another question. And that one is from Paula. We require pre-employment drug tests for all positions. Is it permissible for us to decline employment to someone that tests positive for marijuana that will be required to get a commercial driver's license within 6 months of employment? The position is a safety sensitive position.
Yeah, I think that would be a reasonable position to take, Paula, that you would decline employment, and I don't think you would have a major concern. I don't, as far as the CDL goes, I'm assuming, but I don't know for certain how that interacts with if that's strictly a Missouri licensing or if there's any DOT in there. But regardless, that might speak to the bona fide occupational qualification. But I think that it's certainly reasonable enough if somebody's going to have a CDL and they're going to be driving a vehicle for work, that and you already have a pre-employment screening, that's your policy, that, yeah, you shouldn't have any issue in declining that employment. I might ask you, what you do the pre-employment screening, what's your policy? And I may have missed, I want to look at the question again. What's your general policy for, the drugs and alcohol in the workplace? Is it zero tolerance or just drug-free workplace? What do you have there? Zero tolerance, absolutely then. Yeah, I mean, there's no doubt. I think that, if you have the zero tolerance policy, and even if that person would have, the medical marijuana card, they would test positive, you do the further inquiry and you see that look, in 6 months, you're going to have a CDL, and I assume, Paula, that they're going to be driving. If that's the expectation to get that in 6 months, that they're going to be driving some kind of a big, if it's a tractor trailer, whatever, or if it's just a big truck. But yeah, I think that the safety sensitive, would be a reasonable basis to decline employment in that case.
Oh, we got a good one here.
Let's see. And that was, I'm sorry, Gregory. Yes, that and that is an attendant deal. That paraphernalia is also not, that would be expunged as well, and those should be treated. And now I'm going to look at, let's see. So for your first question, paraphernalia that would be tacked on by that will be treated as expunged as well. So yeah, that's a good point, that, they have to have the tool, I guess, to can ingest it, or at least they used to. Now I guess you have gummy bears and everything else. But for the second question, Gregory, if you have a zero tolerance policy and either show up on the pre-employment background could that be grounds for disqualification of employment? In that case, I would say no. And the reason being that, those misdemeanor offenses, even though they may still appear, they are really to be expunged by the court. The applicant has no control over how quickly they are expunged. And it's really, it's on the courts, and that's why I think the best practice is to treat that, again, if something is expunged, it is as if it never happened. So that would not be grounds for disqualification. It might be, indicative, I guess, depending on how long ago it was. It might be indicative of what they're up to, and you have a zero tolerance policy, but that alone couldn't be the grounds for disqualification. Presumably, you would have a drug test if you on the pre-screen, and if you did that and it comes up positive, then you've got them covered for your reason, because you have that zero tolerance policy. Hopefully that answers your question, Gregory.
Thumbs up. All right. So we do still have a few minutes left. If anyone has any other questions, please, again, unmute yourself and shout them out or put them in the chat. And then, also with this too, kind of leaning on the other side of things. So as you guys know, again, we are the Small Business Resource Center. So we are always looking at different trainings that might be valuable to entrepreneurs and small business owners. Next Thursday, the 27th, we have a training coming up. It'll be from 10:30 to 11:30 as well. And it is for choosing the right entity and licensing your business. So are there any other trainings out there that you guys would like to see? Is there anything that you have questions on that you've tried to research but don't quite get the answers you're looking for? And it could be anything from, how to use Excel 101 to how to use PowerPoint 101, to something like this cannabis training, or like our business licensing training, marketing training. We've had cybersecurity training. So we're always looking for advice on what other trainings that you guys would find valuable. So if you guys have any ideas, we are absolutely open to hearing those. And Janet, yes, thank you. Absolutely. We appreciate that. And thank you for attending today. All right, well, it doesn't look like any other questions are going to be popping up. Oh, nope, Sherry Boyd. We might be getting something.
There we go.
Yeah, thank you, Sherry.
Thank you. Yeah, I hope everybody finds this helpful, just to take up a minute or two while anybody thinks of a question. But, one of the things that is interesting and is problematic about this is, the 2018 medical marijuana law was actually a law where, it went through, all of the legislative stuff. And there's, they call it, it's like making sausage. Nobody wants to see how it's made, kind of thing. But there's a lot of back and forth between, the different factions and what they want to see in it, and what you don't, and, compromises and everything else. Usually when things get passed that way, there's a better framework, and it's a little more predictable. And in this instance, with the constitutional amendment, it didn't have, there wasn't the opportunity for all that back and forth. It was, here's what the change is going to be. And so it's a little different. And I think that lends itself to the whole issue being gray and a lot of, room for development and some fertile ground for attorneys to do things, to try to make law and the courts to, decide it, I guess, or ultimately figure it out. And so it's a developing area. And so everything that I've said today, it could be turned on its head. It won't, not most of it, but you have to be aware and continue to keep an eye out for these developments. But I mean, I think everything we've presented is a pretty sound basis as the amendment is written, and what our best, thought and consensus is as to how things will be treated. But going forward, again, there's changes. I just, when I was looking up for the zero tolerance policy, there's apparently a bill in Colorado that is trying to outlaw zero tolerance policies for employers so that recreational users, and I think Colorado probably has a similar law, but and probably some similar protections, but they want to put it so recreational users can't be prohibited from getting a job because of a zero tolerance workplace drug policy. So, who knows when that may find its way here to the more middle of the Midwest, I guess. But so just food for thought.
All righty, well, it is teetering on 11:30. So with that, we will again say our final thank yous for everyone who attended today. And always, if you ever have any ideas for trainings or needs for training, get a hold of us. If you need assistance with your small business, get a hold of us. We're happy to help. And Dan, thank you so much for being our wonderful presenter today. It is greatly appreciated. You were wonderful.
Well, great, thanks. And like I said, I hope everybody found it informative, and it was. I'm glad to have been able to participate in it. I enjoyed it. Very interesting topic.
All righty, well, we will talk to you soon. And everyone, we hope you have a wonderful day today and have a wonderful weekend.
Indeed. Thanks, everyone.
Thank you. Bye now.
Bye now.